What legal protections do I have against phone tracking by law enforcement?
Hello everyone, and welcome to today's video. In this segment, we will be discussing the legal protections available to individuals against phone tracking by law enforcement. It's important to understand your rights and the safeguards in place to protect your privacy in these situations. So, let's dive right in.
Can law enforcement track your phone?
The first question that may come to mind is whether law enforcement agencies have the ability to track your phone. The answer is yes, they can track your phone under certain circumstances. Law enforcement can obtain information about your phone's location, such as cell tower data, GPS data, or through the use of stingray devices. However, there are legal limitations and protections in place to prevent arbitrary or unwarranted tracking.
What legal protections exist?
2.1. The Fourth Amendment. The Fourth Amendment of the United States Constitution protects individuals from unreasonable searches and seizures. It requires law enforcement to obtain a search warrant based on probable cause before tracking your phone in most cases. This means that they must present evidence to a judge, demonstrating that there is a reasonable belief that a crime has been committed and that tracking your phone will provide relevant evidence. 2.2. The Electronic Communications Privacy Act, ECPA. The Electronic Communications Privacy Act, ECPA, is a federal law that sets standards for government surveillance of electronic communications. Under the ECPA, law enforcement generally needs a warrant to access your electronic communications, including your phone's location data. However, there are some exceptions to this requirement, such as in emergency situations or if you have given consent. 2.3. The Carpenter v. United States Supreme Court case. In 2018, the Supreme Court of the United States issued a landmark decision in the case of Carpenter v. United States. The court ruled that obtaining historical cell phone location data from service providers without a warrant violates an individual's reasonable expectation of privacy. This decision strengthened the privacy protections surrounding location data and established the need for law enforcement to obtain a warrant in most cases.
Additional considerations.
3.1. International laws and regulations. It's important to note that the legal protections against phone tracking can vary between countries. If you are located outside the United States, it is essential to familiarize yourself with the laws and regulations specific to your jurisdiction. 3.2. Privacy policies and consent. While the Fourth Amendment and the ECPA provide legal protections, it's also essential to be aware of the privacy policies of the services and apps you use. Some companies may collect and share your location data with third parties, including law enforcement, based on your consent or their terms of service. Take the time to understand the privacy practices of the platforms you use and make informed decisions regarding your privacy. In conclusion, there are legal protections in place to safeguard individuals against phone tracking by law enforcement. The Fourth Amendment, the Electronic Communications Privacy Act, and the Carpenter v. United States Supreme Court case all contribute to establishing the need for a warrant based on probable cause in most cases. However, it's crucial to stay informed about the laws specific to your jurisdiction and understand the privacy policies of the services you use. Remember, knowledge is power, and being aware of your rights and privacy protections is essential in the digital age. Thank you for watching, and stay safe.